السلام عليكم ورحمة الله وبركاته. My name is Fawaz Al-Qahtani. I'm a IB Commercialization Manager for ICT. I work for Industry Development and Technology Transfer Office, Research, Development and Innovation under Qatar Foundation. Today, I will be talking about the essential IB for internal rules and the new startup. So the agenda of the talk today, first we start why IB, why IB matters, and then what's the IP. We look at some different aspects of IP like patents, copyright, trademarks, and then we look at how to strategize IP protection and align the IP to into your business strategy. Then we look into some challenges and opportunities related to IP commercialization in Qatar. And then we will close the talk today with some examples, some of the startups that been created based on QF research outcomes since 2018. So before we jump into IP, I would love to give you introductions about the Industry Development and Knowledge Transfer Office. For our office, since our office is part of Qatar Foundation, it's our mandate to support Qatar Vision 2030 for knowledge-based economy. If you look, and first we define what's the knowledge-based economy. Definitely it's based on the innovations, new ideas, which are the currency of the knowledge-based economy. So to do so, then identifying, protecting, and commercializing IP developed here in Qatar is very essential to achieve such a mission. It's not easy. For example, Qatar Foundation started 2018 with the Qatar Science, Qatar National Research Fund, and right now we are reaching a stage where our products and our research outcomes, it's been successful into the market worldwide. So if you look to our office objectives, it's protection and value creations through intellectual property management, transfer knowledge through commercialization and licensing, and this usually under tech transfer offices, tech transfer office. If you look to the tech transfer, it went through different stages, and right now I think we are in the, started in 1985, and right now we are in the third theme of technology transfer offices. There are always lots of conferences. Most of universities worldwide try to enhance the policies that support the technology transfer, which can be adopted by international universities. Enhancing the innovation ecosystem through industry support and business development. We strengthen community through innovation management, recognition, and training. And we are glad that we are working with Ruwad since 2018 for giving talks and training for entrepreneurs and for an early startup. So what we do exactly, first we have the IB asset management. We look at the new IBs, we look at the research outcomes, and we try to find, identify the potential of the research outcome that can be protected. If we, our office, we do the evaluations, the protections, and that based on some criteria that we adopt and we follow, and then we decide if we protect or not. We have a IP protection management, IP dissemination, licensing, commercialization. That's basically the core of our work. We have technology development. Usually we close the gap between the IP and the commercial product. Most of the IP, it's early, it's called technology readiness level, which is vary from 1 to 9 or from 1 to 8. And usually we have 1 to 2, 3. We try to support with technology fund that researcher, they can work to develop their technology to reach 6 and 7, and that make it easy for them to take it to the next step. We have research industry collaborations, and then we have culture development, which is one of our key point of our office, which is training, guidance, recognition and reward, and revenue distribution for those who get involved within the research outcome. So as I said, the IDKT core functions, we have three main core functions, which is innovation management recognition. We have intellectual property management, we have commercialization licensing, and we have industry support and business development. We've been recently focusing on industry support and business development, just only to support researchers, as I mentioned before, with the fund that can help them out to develop further their technology and take it to the market. Right now, our focus is just only to generate or to have research. We start with something called the revenue generation based on our research. If you look at our QFIP outcomes since we started 2007, when the QNRF started Qatar National Research Fund, until today, we received 740 information disclosure reports. Though 2020 been very tough for everyone because of the pandemic, we have received, which is the highest among all the years since 2007, which we received 130, and we're expecting to receive 10 more until the end of the year. And we've been successful as well. We have licensed this year three exclusive licenses, which is based on our outcomes with new business or startup based on our technology. We have licensed around 3 to 4 non-exclusive licenses. We have given 5 evaluation licenses, and I'm glad that we stakeholder here in Doha, they are working closely with us. One example of our collaboration, we are working with Karwa closely, where we developed a new technology called Kharta. It's replacing Google Map right now. It's if you go to Karwa Taxi, then you will see Qatar Science, Qatar Computing Research Institute technology there. Our stakeholders we have within our office. We are managing all Qatar Foundation universities and campuses, Hamad bin Khalifa University, all the colleges within Hamad bin Khalifa. We support Qatar Science, Qatar Computing Research Institute, Qatar Environment and Energy Research Institute, QBRI, Texas A&M, Qatar Biobank, Sharib Properties, Sharib Al-Aqariyah, that's within QF. And for the others who are non-QF entities, we support Hamad. We manage their IP, Hamad Medical Corporation. We take care of Star of Science participant. We take care of Qatar Science Club. We have Al Khabir program, which is support the entrepreneurs with the Qataris who are coming from organization within Qatar, like Qatar Science Clubs or any incubation center within Qatar. That's the main work of our IDKT. I encourage everyone who's interested to pursue or build his own startup to visit our website, idktqf.org.qa, and you will find many materials that can help him or direct him to the right direction to have a successful startup. So first, before we talk about what's IP, why startup or entrepreneurs interested in a patent? We know patent is very expensive. Usually startup was started with a less budget. So why they should, why it matters? First, it attracts investment. Like any investor, most of the investors, to minimize the risk from their side, they want to make sure they want to deal with the startup that they have a technology or idea that is protected in a patent. So usually investors, they don't read the application, but when they come to you and they say, "Oh, I have a technology and I protect it within a certain market," they want to make sure like the risk is minimized. So they will definitely come close to you, and you will have a high chance these guys they will invest in you. Prevent the theft of innovation by third parties. If you look to the most of the startup, when they started, they don't start alone. They usually outsource things. They work with the collaborators, with the third parties who work with them closely. And with the working with the third party, then they have a high chance they will expose to your idea, to your product, and the invention behind your work. And then if you didn't work with them, after some time, this guy, they may pursue and they develop the technology. So if you don't have the protection, then third party, they may infringe and take your work. Protect their, one of the benefits is as well, protect their competitive advantage, offer the products within the market, use IP as a marketing edge. For example, if you didn't develop the technology to be going to the market, you may use it as a potential revenue stream through licensing. You develop something and you can sub-license it to many companies, and that can be a great revenue, and avoid litigation against big companies who may infringe your work. So when is the best timing for a patent for any startup? A startup should consider whether to obtain patent protection. So it's better to have protection 2 to 4 months before trying to obtain VC or other funding. So if you feel like you come to a point that you need a VC, then make sure like you have protected your work before you talk to them. And then if you feel like you want to disclose your technology, you want to present, you want to do pitching, before you contract with a third party, make sure like everything is protected before you go ahead, because most of the lost cases, it is within this case. So, the best timing when to protect is when the company is on the track to take away competitor market share. So before you jump into the market, then make sure like you have the protections in place. So the benefits of successful startup. So the information I'm presenting to you right now, it's based on a reference called entitled The Bright Side of Patents. It's from Harvard Business School. So it says like a successful startup based on a patent, it's more likely the growth of the employment reaching 36% over 5 years, sales growth increase 55%, increase likelihood to secure VC funding over the next 3 years. And by the way, when you have really great patents, usually CEO of the startup, they seek funding, but when you have standalone patent, then most likely VC, they will reach out to you to invest in your company. Double the likelihood that the company is eventually listed in the stock exchange. So it's promising, and I think everything that we mentioned, hopefully it's convincing everyone who's interested to build this startup to make sure like a patent to have it in the first place. Okay, you know, if you look to the intangible assets of Amazon and Apple, right now, both companies worth more than 1 trillion, and I think Amazon, it's more than 200 billions after 1 trillion, and that's mostly 80% of the company worth is just of intangible assets, which based on the know-how, IP, trade secrets that they have. Okay, so right now we'll start with some definitions. I think definition is very well known. You can find it anywhere in Arabic, in English, and different languages. Simply find that there are many YouTube, which I encourage everyone to take a few courses or a few briefing about what's intellectual property. So intellectual properties, and we need to most of individuals, they don't know exactly what's the difference between IP or patents, copyright, and trade secret, and all this stuff. So which we are talking about in a bit. So IP is something produced using human intellect, which has a commercial value. Any ideas that developed by human intellect can be intellectual property. So IP, it's the creation of mind, intangible property. It can be invention, can be original work of authorship, discoveries, experimental processes, experiment know-how, and many others. So if you look to the what's the difference between IP and patent or copyright, then the legal right given by the country is known as, or are known as a patent or copyright or trade secrets or trademark. That's the difference. So IP is general, and the legal format of each one is the name of what type of intellectual property you are going to. So two types of IP protections. It's broadly divided into two categories, which industrial properties, that's based on patent for invention, trademarks, trade secrets, and industrial designs. And that's where we start up. We have them nowadays in the market. They are under this category. And then we have copyright-related rights, which is belong to literacy works, a poem, novel, plays, film, music, and these they are under copyright. Copyright is definitely it's one direction by itself. It's huge. There are lots of things we need to learn about if anyone want to understand it fully. So patent. What's a patent? Patent, as I said, it's legal right, and usually it's granted by the country. If you are here in Qatar, if you develop this technology, so what will happen, you will apply to the Ministry of Commerce, and then they do evaluate your patent. When they evaluated your invention disclosure, when they find it's unique, then they may give you a grant saying this is exclusive right to person X, and this is basically to provide you, it's a protections for 20 years that protect anyone not to use your patent without your permission. So basically it's a deal between the inventor and the government. And usually to have a patent, so there are 4 things need to be met, which are first, it need to be novel, new, non-obvious, useful, and under public principles. So what's non-obviousness? When I talk about non-obviousness, it's something new which is definitely not new for individual. It's just only the person who are skilled, the person who are expert in any kind of technology or any type of matters. For example, if you look to someone who works within artificial intelligence, who works with the automation industry, then they know most of the technology. When someone produces work, that this work, it's new for these guys. So when these guys, when they look at it, they said, "Whoa, we've been in the market for the last 20 years. We think this is the first time we saw such work." So this is non-obvious to the expert people in the field. Then we talk about the novelty or new. This invention must be new and not known already to the public, to the prior art. So when we talk about prior art, we said it's all the information that has been made available to the public in any form before a given date might be considered. So if you want to protect something, make sure it's new, make sure you didn't talk about it, you didn't say anything about it in front of anyone, you didn't present it, you didn't have it in article or brochures. So sometimes people they publish their work, and later on they feel like they want to protect it. So mostly worldwide, they cannot protect it anymore unless just only the US only US application can give you 1 year time. For example, if you have disseminate your outcomes in January 2020, then you have time from January 2020 to 2021 to protect it to the United States only, not anywhere else. So how can I tell someone about my invention and avoid it becoming prior art against my patent? Information kept secret is not usually considered prior art, so disclosing and then a disclosure or NDA agreement usually avoid any prior art. So before you talk to someone, make sure you have NDAs, and there are always NDAs. You can use them. Most of the legal offices worldwide, they have them for free. It's most likely it's general template, which you can use it and let others who will expose to your technology to sign it before you talk to them about your technology. And then one of the requirements is usefulness, which provides some identifiable benefits and is capable of use. So anything patented and then translated to something that can be useful to a human being, that's its usefulness. It needs to be within a patent, public principle. It needs to be, it doesn't go against public morals, like here in Qatar. It shouldn't go against the Sharia law of Qatar. So what can be protected? What can be patented? Sorry, patented. It's a huge. There are huge areas that can be a huge line of research, line of areas that can be protected. I encourage as well some startup, they want to know exactly where the technology they are heading off to. So I encourage them to visit our Qatar Research Development Innovation Council. They look at the Qatar 2030 vision, so you can go with the direction of research. And at the same time, I encourage people to visit our website, idkt.org.q. I encourage them to visit Qatar National Research Fund to look at the research direction for the next 5 years. And usually these strategies is based on the market potential, which make it easy for startup to focus on. So what can be patented? Method or processes, machines, any machine that accomplish a task, a certain task, articles of manufacturers that's made by a human or machine, compositions of metals, chemicals, any types of new chemicals that can be protected, or any of two combination, for example, machines plus method or processes, new uses for any of the above. That can be patented. What cannot be patented? Usually idea alone by itself, it's not protected. Ideas need to be translated, need to be fully described in a format with the drawing to tell people like what your ideas does and how it works and how can that be useful to the human beings. So what cannot be patented as well, natural occurring phenomena, law of nature, mathematical principles. You know, there are many principles that hasn't been solved yet. If anyone solves a new issue, a new problems, then that is not patented as well. So what's patent right? It's the right to exclude other from making, using, or selling your patented technology for a period of 20 years from the filing date. So when you have a patent, then it's your own properties for 20 years. No one can use it without your consent. So here we look at some of the defined claims or claims define property right for a patent. For example, if you look at prior art, cycle with a wheel, 2 pedals and a seat. And then, for example, your claim is a bicycle with 2 wheels and 2 wheels and a seat and handlebars. This, you know, your claim, it can be protected, but if you look competitor A and competitor B, it's a bicycle with 2 wheels and 2 beds. It's just only combination of the others, or bicycle with 2 wheels and 2 beds. It's just only, so these two, it cannot be patentable. So here is a simplified patent process. So if you want to patent your work or your product, then you have to prepare and file application. You have to, for example, in Qatar, you have to reach out to Minister of Commerce, to the patent office. You apply large applications, you pay certain fees. Patent office, they will review the application. There will be office action. If all the claims are accepted, then patent granted. Otherwise, it will be rejected. It will refer back to you. You can argue the first time, second time, and I think third time it will be rejected. That's the simplified one. So the general one, it's a patent, what's called patent cooperation treaty. Usually, you cannot patent your technology worldwide at once. There is no, so if you are interested to protect your work or to your invention, then you have to go to all the countries and then lodge application there and apply for. So BCT usually it's a treaty, more than 152 countries they are involved with that one. Some of the country, for example, application when you apply the first day when you applied, then all the countries they know you will be having the priority date before anyone else. So on this one, what's a good thing about BC? When you start as a startup, you know, you have 30 months. So you pay a small amount of money, you can work on your technology, you can develop it further, and by 30 months, at that time, the companies grow, you know exactly your patent, if it's can make, if it's, it can go to the market and can make tangible revenues. And after 3 months, I think you will be having clear pictures if you want to pursue to protect it somewhere else. So after 30 months, that's called the BCT international phase, where you can later on, you can choose which are the countries that you want to protect, where the market or your product want to go to based on the market or the financial projection that you have. What's the best patent strategy? So most common strategy, this is why I advise entrepreneurs and startup. You apply for provisional patent that US doesn't cost a lot, it's very cheap. You have 12 months, you can develop your technology and then you have it in US. Or file a BCT 18 months as well. You have some time to develop your technology. After the 30 months, you can apply to the specific countries and the specific countries we'll talk about it. It's based on the rule of thumbs. Factors to consider. For example, if you go to many countries, then you have to look at the size of the market. Where are the manufacturing centers? Where are the emerging market? What's the lifespan of product? And demand for product country. Approaches can be targeted regionally, internationally, global. So the only way that you can protect for different countries is through GCC. Countries, they have one applications, they have one office, which is in Riyadh, which, for example, if you're protected there, then that means you will be protected within all GCC country. Rule of thumbs, must have US and European patent office, that's when you start. Then you look for very large economies, China, Japan, India, large economy, Russia, for example, GCC, English-speaking countries, Canada, Australia, South Africa. And you can look at the growing economy countries like Indonesia and Thailand as well. So the cost, initial filing, is from 2012 to 25. That's called including patent drafting prosecutions. Some additional countries require fees from 2 to 10. And then you have the annuities per countries later on after, I think, 2 years when you filed, which is from 200 to 1,800. So general patent filing process, it's start with application, publication, then you have the office action come to you, then you will have response to that action. If they, for example, they challenge you some of their claims, you can rebuttal back to them and say, you can elaborate more. Examiner allow patent, then based on your feedback, examiners, they allow patents upon receiving the appropriate response. If it's not appropriate, then they reject it, otherwise patent can be issued. And then after the patent, the maintenance fees come to place. Okay, we are done with the patent. Right now we are looking at the copyright. So copyright is, it's defined as a legal right created by the law of the country. So every country, it has its own right, copyright or legal right. If you look to US, they have the copyright is different from state to state as well. So most of the state, they have the one law, but if you look to California, they have their own law of copyright. So copyright is basically it's a legal right that grants the creator or of an original work exclusive right to use it and distribute it for limited time, which is around 75 years, with intention of labeling the creator. It can be a photographer or photograph, the author of a book, and it can be a film, it can be a script, it can be, and there are many that can be protected through copyright. What can be copyrighted, as I mentioned, it can protect original literacy, music, artist work, computer software, engineering, drawing, and at the same time, engineering drawings and computer software when it's working with the hardware or there is an algorithm behind it, then you can have a patent and a copyright at the same time. So copyright granted rights, generally author's life plus 75 years, for companies work for hire, 20 years from creation, or 95 years from publication. That's for the copyright. If you look to the trade secret is very well known. It's known as a confidential information. Most people, when we talk about trade secret, they think of Coca-Cola, they think of KFC. Some of the example of or recipes, and even I think in Qatar here we have some recipes which is still trade secret. Some of the manufacturing techniques can be trade secret. Usually the patent itself, when you patent something, we advise people like some of the patent, after sometimes it gets granted, it will be published. When it's published, that means it will be exposed to the others, and some they may use it and they develop it. So it's good sometimes to keep trade secret within your patent, so you make sure like no one can emulate or reproduce what have you done. So trade secret can be for the business plan as well. So a business plan need to be secret for startup, for early companies, even for companies. So, and that includes customer list, company future plans, product, advertisement, competitive information, consumer data. These, they need to be, so we know it can be, we know that the way of trade secret, people when they come secret, come to their minds Coca-Cola and the other, but no, within your company, it's good to have things, trade secrets for your startup. Since you are just started, make sure like everything you have kept secret with you, and make sure like when you people like join your startup, make sure like the agreement or the employment agreement with this individual, make sure like the trade secret is mentioned and the IP protections for your ideas, not to, even if they leave their work to go to the startup, they don't refer it to someone else or to another startup. So trade secrets are really not rights. You don't have to register them to give you the right legally to sue unauthorized use or disclose of information. Like for example, if someone works with you and he knows your technology, you have the secret, and he works with different startup or other company, and he take your idea and give it to them. That's, I think from there you can sue this individual for doing so. Okay, trademarks. Trademarks is any design or expression which identifies a product or services. It can be name, can be logo, can be brand name, color, shapes. Some of the companies, you can have trademarks and trade secrets at the same time. So for example, Coca-Cola, they have trademarks of Coca-Cola, and at the same time you have the trade secret of the ingredients of the Coca-Cola. So we have here, for example, many trademarks we know here in Qatar, like the new, for example, like Synonym, Rafiq, these trademarks which we know, Baladna, and some others. So how to strategize IP? Developing IP strategy need not be difficult. So what I want to protect first, how best can I protect, when to file and where to file. So usually startup, they have to have these 4 questions and ask themselves and answer them carefully before they start their work. So what do I want to protect? There are general misconception. Business model innovation is patentable, some of them, and ideas are patentable. So we have to make sure this is misconceptions. So business plan definitely is not patentable. Ideas, if the idea doesn't translate it to something usable, then it's not patentable. So ideas can be the ideas can move to inventions, and that's by doing the process of invention, and then goes to the process of innovations. And the process of innovation, you take the invention and deploy it and make the use of it. How to choose the right type of IP. So the IP, what we talk about is a patent, copyright, trademark. You can have patent, copyright, trademark at the same time. You can have a patent, can have copyright of the software, of the text behind it. You can have a trademark of the product that you are building. So protection barriers, patent, we know that 20 years, copyright 75 years, and trademark, it's the period of protection varies, but I think registration need to be renewed based on the country you are registering in. What about trade secret? Trade secret, it has much weaker protection than patents, and the reason for that, because it protects you from employees who leak confidential information that we talked about previously, or companies that steal your technology. So make sure like the employment agreement, make sure like you have everything in it to protect your to work. Not anyone can infringe your work or disseminate it to someone else. It does not protect you from competitor as well that independently develop your technology. In fact, your major competitor can patent the same invention and sue your company for infringement. So other IP matters that we entrepreneurs and startup, they should be aware of. First, you understand your IP position. Do you have freedom to operate? For example, if you're working in a software, for example, e-commerce, if you are working fintech, then definitely when you are building, for example, a payment system, you will be using different, different source code, open source code. Make sure you have your license, any technology, anything encompasses you. For example, if you have product, encompasses of 4 or 5 things, 2 of things it's you, make sure like the other 3 you are licensing, so to avoid infringement later on. And then you have to know what's your scope of protections, and you have to resolve all the ownership issues. Who've been involved in the beginning with you, make sure like some of them, they start with you like, for example, in the early stage of the startup, and they leave and you just pursue it by yourself, and later on they claim, oh, we were one of the participants in the early stage when we started with the CEO of the company, with the guy who initiated the idea, and this may cause you a problem. So be ready for due diligence, verify all IP has been assigned to a company, review license agreement, make sure you talk to the right attorney, identify third-party claims to companies' intellectual property, review the company's trade secret protections and measure. These ones, you can find it anywhere. We always talk to entrepreneurs. We always encourage them to seek attorneys' feedback when it's needed. What other IP matters that you should be aware of? Avoid contaminations. Make sure employees sign a contract to assign IP to startup. Make sure contractors sign contract to assign work to startup. These 2, they are very important, and most of the startup, they deal with it. So, and one of the contamination as well, don't start a business on a name that cannot be used. Try to be unique. Use the name that can identify, can represent your business, your product, and you can use it all the time. It may last with you for forever. So what's the protection takeaway today? So patent protection takeaway must be lawful, non-obvious, or for the prior art. The invention is described in the detail. It must be described in details, detailed description and drawing. What others can be excluded from is described in the claims. Patent can cover utility or design of an invention, provisional or non-provisional application. When I say the provisional application, that's when you go 12 months. That's what's very cheap. It can protect your work for or PCT for 12 months or 30 months. with a small amount of money. During that time, you can build your own business. The value of the company might be more. So later on, you go for non-provisionals, which are more expensive. You can afford it and you can protect it to receive a full patent. What's the copyright protection takeaway? Today, we know that protection from productions, derivative work, from distributions, standard clause, and source code is not patentable, protects original code, not the created one, created automatically with authorship, best to register. It's best always to register with the Copyright Office. Trademark protection takeaway: protect a name associated with a particular product, with a service. Mark may be a name or symbol, as we mentioned. Mark must be distinctive. General names can be protected. You have to be, as I said, distinctive in choosing names. Protection obtained by use and the filing mark registration with the United States US Patent Trade Office. So the strengths of the mark, usually the strengths of the trademark or the mark is using it. If you didn't use it, then you lose it. So I think we covered all the IP matters that entrepreneurs or startup, they need to have to know about them. We encourage research. We encourage entrepreneurs to reach out to us if they need further information, further consultation. We are happy to provide them with all the necessary information they need to have a successful startup. So right now, I will give you guys or everyone some examples for our IPs that developed by our researcher within Qatar Foundation. So the first startup, it was in 2018. It's from research to startup program. So here we have technologies called 2D to 3D. So we started it's two types of invention. First invention, which is a core based on the core 2D, 3D conversion. The CEO of the company, it's called Trademarks.ai. He pursued protection for 9 to 10 countries. He protected in US, protected in GCC, protected in Germany, Japan, India. Why he did that one? He studied the market well, and definitely it can be easily implemented anywhere else. So this technology, usually I call it, it can cross the boundaries easily to any country. So he's working right now. The startup right now, they're working closely with. They are developing great technologies. They are talking to big companies in US, and I'm pretty sure they will be succeed in the future. So what do? They use 2D, 3D. It can be used for gaming. It can be used for for film, for virtual realities. It can convert 1080 HD to 8K in an efficient way. So this one, it's internal fund from Qatar Computing Research Institute. The development, it took 4 to 5 years. The technology readiness level was 6, as disclosed to us, and really it solved a real market problem. So the second one, it's Tamer. This is started in 2018. The value of the company right now, it's 70 million, or the total of funding. I think it's worth more. So it's basically, it's more a system which is cost effective. It's used for data cleaning. It can be used for AI. What do they call it? SaaS, software as a service. So it's through QCR internal funds, 2 years of development. When disclosed to us, it's why TRL8, which is ready to go to the market, solve a market problem. So we have technologies called Persona. It's called analytics, which is It's called automatic persona generations. That basically it's AI-driven segmentation, real-time customer data analysis, visualize and understand. So what does it do? Understand the persona and customer preferences. It can give the companies the sense of the customer preferences, what they want. So the companies, they can direct their product toward to the customer preferences. So providing SaaS solution. This is 5 years development with the 3 researchers. I know them closely. It's from internal fund. When it's disclosed to us, it was TRL level and solve market problem. So Canary AI, we for this company, we license it as a full exclusive license to a US company. It's as a startup. It's called Canary AI. So it's 9 years of development. It's called CAT, which is KCRI Advanced Transcription System. Sorry, it's convert speech to text using state-of-the-art speech recognition technique. It can transcribe Arabic and translate it into English, or the other way around. So I think CAT this is one of the. It has a strong dialect system. I think it's used for Al Jazeera for many years. It's still used. It's used by Shura Council here in Qatar. We give it to different companies here in GCC countries for non-exclusive. It's been, and CATS right now, it's one of the well-known, it's one of the best technology that can do transcription and translation at the same times, from voice to text worldwide. So right now it's, as I said, 9 years of development. TRL level as disclosed, solve market problem. And right now we have, and they are investors who are interested to invest in Canary shortly. With this, we end up our talk today. Hopefully we passed enough information to everyone. If you have any question, please, I'm happy to answer them. If you have any concern, please reach out to us. We are in Qatar Science Technology Park, 2nd floor Innovation Center. We welcome you guys anytime. We are happy to answer your questions and to provide you with all the necessary information that you need. Thank you. So there's questions raised by Yara. It says, could you repeat the sites that will give us oversight of the 5-year innovation strategy? Could you repeat the other relevant site? So I advise you to go to IDKT, which is Industry Development and Technology Transfer Office. That's, if you type it within Qatar Foundation, you will have access to the website. The second one, Qatar National Research Fund. If you go there, you will find all the needed information. If you go to the Qatar Research Development Innovation Council, you'll find the website with all the necessary information, which talk about the future or the next strategies for the R&D and innovation. Second questions, it says ما هي المدة التي يحتاجها صاحب المشروع لإنشاء الرخصة وما هي الرسوم لغير القطريين؟ I think this question is not relevant to what we are talking about. I think to have a business here, I think you have to have a Qatari partner, or if you want to build, that's you have to go and talk to Qatar, the Ministry of Commerce. But for non-Qatari, I think we have the free zone, and we have Qatar Science Technology Park. It's a free zone as well, and yeah, it welcomes people like non-Qatari one. You can open your company within the QSTB as well. So if you need any information, if you seek assistance, then I advise you to visit Qatar Science Technology Park, and you will have you will see, and you will have all the necessary information to open your startup or your company within QSTB. Any questions? Is it common to find the startups that use investors' money to create their patent. Usually investors, they jump into a startup when they have when they are already in the early stage, and it's possible. Yeah, it can be. I mean, if you have a clear business plan, I think if you have the scope of your business plan is very well defined, if you have strong financial projections, if you study the market very well, present it nicely to the investors, they are very smart. They know exactly what's in the market and and they know exactly what makes sense or not. So this is possible as well. Yes. Any questions?
I think this is all the questions we have. Thank you, Mr. Fawaz, for this very insightful workshop. Thank you, everyone, for joining. I think we will sign off right now.
Okay, thank you very much. Thank you. Yes, thank you, everyone.
Thank you, Mr. Fawaz.